Go into chat.
Ah, okay.
The first one.
Yes, of course.
Got it?
Great. That's
and
great.
all of you will have access to the Q&A, but I'll take care of the Q&A. All right. Good afternoon, everybody. It is my great pleasure to introduce this panel entitled Writing as Resistance, the Role of Literature in Law and Society. My name is Penelope Andrews, and I am a professor at New York Law School and also the president of the Law and Society Association. My task on this panel, I'm the chair and the organizer of the panel. I'm going to briefly introduce the speakers. These speakers are incredibly accomplished human beings, and so what I'm going to tell you in their biographies is just a fraction of what they've done. And then I'll hand it over to Kendall Thomas, who will be moderating the session. Please direct all your questions to the Q&A tab at the bottom of the screen. So let me start with Kendall Thomas, who is the Nash Professor of Law and the co-founder and director of the Center for the Study of Law and Culture at Columbia Law School, where he leads interdisciplinary projects and programs that explore how the law operates as one of the central ways to create meaning in society. He is a founder of Amend the 13th, a movement to amend the US Constitution to end enforced prison labor. Kendall is a scholar of comparative constitutional law and human rights, and his teaching and research focus on critical race theory, intersectionality, legal philosophy, feminist legal theory, and law and sexuality. His seminal writing on the intersection of race and law appears in Critical Race Theory, the key writings that founded the movement, which he co-edited. Kendall was an inaugural recipient of the Berlin Prize Fellowship of the American Academy in Berlin and a member of the Special Committee of the American Center in Paris. He has been chair of the Jurisprudence section and the Law and Humanities section of the Association of American Law Schools. And a well-known secret, Kendall is also a professional jazz vocalist who has performed at venues including the Algonquin and Joe's Pub in New York. The next person I'd like to introduce you to is Qudsia Mercer, who currently teaches Islamic law at Birkbeck College, University of London. Qudsia has taught at the University of East London, Albany Law School, Washington and Lee University Law School, and the University of Cincinnati Law School. She has held research fellowship positions at the University of California, Berkeley, and a visiting fellow in the Islamic Legal Studies program at Harvard Law School. Qudsia has been appointed to executive and advisory positions for a number of organizations, including the Joint Council for the Welfare of Immigrants in the UK and the Contemporary Arab and Muslim Cultural Studies Institute, University of North Texas. She has been a member of the editorial boards of Muslim World Journal of Human Rights and Social and Legal Studies. Qudsia's research focuses generally on Islamic law, particularly feminist perspectives of Islamic law. Her other strand of research is legal pluralism, the operation of state and Islamic laws as legal cultures in the British and United States context, and the nature of religious identity. She has published in these areas and is currently editing a collection entitled Islam, Feminism, and Legal Cultures. Val Napoleon is the Law Foundation Professor of Aboriginal Justice and Governance at the University of Victoria. Hi, Val, you want to wave? Val's current research focuses on Indigenous legal traditions, Indigenous feminism, citizenship, self-determination, and governance. Some of her major initiatives include the JID, which is the Joint Law and Indigenous Law Degree Program. And she's also established the Indigenous Law Research Unit with a number of research partnerships with Indigenous communities and groups in British Columbia, across Canada, and with international connections. One of Val's projects is a 2-year Indigenous, non-Indigenous water law research project, Gender and Indigenous Law, Dispute Resolution, Indigenous Lands and Resources, and Human Rights in Indigenous Law. Val has taught and published on Aboriginal legal issues, legal theories, Indigenous feminisms, governance, critical restorative justice, oral traditions, and Indigenous legal research methodologies. Val is a member of the Saulteaux First Nation in Canada. Ruthann Robson. Ruthann is a professor of law and a university distinguished professor at the City University of New York School of Law, and she is a teacher in the field of constitutional law and sexuality and law. Her legal books include the casebook First Amendment, Cases, Controversies, and Contexts, Dressing Constitutionally, Hierarchy, Sexuality, and Democracy, Sappho Goes to Law School, and Lesbian Outlaw, as well as editing the 3-volume set Sexuality and Law. She is the co-editor of the Constitutional Law Professor's blog and a frequent commentator on constitutional and sexuality issues. Ruthann is one of the 26 law professors featured in What the Best Law Professors Do, which was a book published by Harvard University Press, in which 26 of the most accomplished, the best law professors in the United States exhibited their teaching methodologies. In addition to her legal work, Ruthann is also the author of creative works, as well as essays, short fiction collection, novels, and a collection of essays. And she's also published a poetry collection. And then finally, last but not least, Patricia Williams. Pat Williams is one of the most provocative intellectuals in American law and a pioneer of both the law and literature and critical race theory movements in American legal theory. She serves as the University Distinguished Professor of Law and Humanities with a joint appointment between the School of Law and the Department of Philosophy and Religion in the College of Social Sciences and Humanities at Northeastern University. Pat's books include The Alchemy of Race and Rights, A Diary of a Law Professor, which was named one of the 25 best books of 1991 by the Voice Literary Supplement, and one of the feminist classics of the last 20 years that quote unquote literally changed women's lives by Ms. Magazine. Pat has authored hundreds of essays, book reviews, and articles for leading journals, popular magazines, and newspapers. She also authors a widely read monthly column in The Nation. Pat has received numerous awards for her work, most notably the MacArthur Genius Fellowship in 2000. Pat's current research includes 3 books in progress: The Complete Mad Law Professor, which is a compilation of The Nation columns; The Talking Helix, which is focused on bioethics and genetics; and Gathering the Ghosts, a literary and historical text based on her family archival materials. In addition, she's working on a documentary film that knits together a narratively linked series of video images about the deaths of unarmed citizens, beginning with Trayvon Martin. Sad to say that another person was murdered by the police yesterday, Pat. So I'll hand this over now to Kendall Thomas, who's the moderator of the session. Thank you.
Thank you very much. I've accepted this opportunity to moderate this panel of distinguished scholars, not least because it allows me to thank, with 3 honorifics, Penelope Andrews, who, as you know, is a professor, who has also been a dean, and is now the president for this year of the Law and Society Association. So I will use this triple honorific, which gives me great pleasure to use. Thank you, Professor, Dean, and President Andrews.
Thank you, Professor Thomas.
And hello to all of you in the vast world of the law and society community. Like you, I am sad that we are not able to be with one another in person, but I do think that this virtual world and intellectual platform that the Law and Society Association under the leadership of Penny Andrews has provided to us is a rich lifeline from wherever we are to our joint intellectual venture as members of Law and Society and Law and Society scholars. Now, many of you will remember that the scholarly debate on law and literature in the 1980s and 1990s was preoccupied, and not always productively so, with two concerns. One was the formal or aesthetic question of whether law is like literature, and if so, in what ways. The second focused on the interdisciplinary question of whether modes and methods of literary study, in particular post-structuralist or postmodern literary analysis, can or should be brought to bear on the interpretation of legal and of legal materials. And those of you familiar with that scholarly debate will also recall the singular and single-minded obsession during the 1980s and 1990s with the utilitarian, instrumental, and purposive conception of the concept of interpretation. And it seems to me that looking back at that scholarly debate from the distance now of several decades, we are in a position to ask a fresh and, to my way of thinking, much more interesting set of questions about how, and if so, in what precise ways the question of law and literature should matter to us today as law and society scholars. And I cannot think of a better panel to address that set of questions than the panel that President Andrews has assembled to speak to us today. And we are going to hear from them in alphabetical order. They're going to present for 8 to 10 minutes, and then open up the virtual floor to conversations for the remaining time. So our first speaker is going to be Qudsia Mirza, who is coming to us, I believe, from London.
That's
our
right.
second speaker is Val Napoleon. We'll then hear from Ruthann Robson, and then from Patricia Williams, in that order. We'll hear first from Qudsia.
Thank you very much, Professor Thomas. Good morning, good afternoon, or evening to everyone, and I hope that you're all well in this rather surreal time we find ourselves in. Like Professor Thomas, I'd like to just say it's a sunny Denver today, but it's gratifying to see that we've been able to come together in this virtual space. And my thanks to Professor Andrews, Penny, for the invitation to participate in this, which I'm sure will generate much discussion and a great deal of dialogue. The title of my paper is Islamic Feminism, Law, Literature as Resistance, ? So I'm posing it as a question. And I want to address the fact that although there's a rich tradition of Muslim feminist literature, and it's an expanding contemporary movement, Islamic feminism, which has really gathered pace, I think, particularly within the last 30 years or so, the nexus between law and literature has not been explored as fully as it could be. And I would argue that actually there's almost virtually no relationship between the two as Islamic feminism is concerned. And I feel that there is great unrealized potential in exploring literary texts which could perhaps enhance and strengthen our understanding and our critique and the exploration of possibilities for reform within Sharia or Islamic law. But first, let me start off with providing a very general overview of what I mean by Islamic feminism. The rapid democratization of religious knowledge and the fragmentation of religious authority we're witnessing in the contemporary Muslim has created a flourishing environment in which rising numbers of Muslims are participating in debates on, in inverted commas, normative Islam. Muslim feminists are reinterpreting Islamic sources in order to achieve equal rights and gender equality within an Islamic discursive framework. And they're challenging traditional interpretations of scripture and received notions of interpretive authority, and the development of contemporary Islamic feminism really has gathered such momentum that it really can be identified now clearly as an international coalition of scholars and activists. Advancing new interpretations of scripture and tradition and arguing for the adaptation and modification of Islamic precepts in both Muslim majority as well as in diasporic Muslim communities. Such interpretations are based upon an understanding of Islam and Sharia, Islamic law, as shifting and contested rather than as fixed and static. The latter is regrettably a much too common representation of both Islam and Sharia throughout history. By perpetuating the notion that Islamic norms are fixed in a patriarchal tradition, Sharia standards have been characterized as immutable and inimical to the rights of Muslim women. So really are looking to the time of Islam's origin and assert that women who had played a significant role as the creators of oral texts really became invisible after the inception of Islam, both as originators and as interpreters of such texts. Scriptural literature was then produced by men who incorporated their own restrictive assumptions and understandings of gender relations. And legal texts were also created in a way, and a masculine bent was really inscribed into the legal literature of the time, resulting in a considerable constriction of the egalitarian ethos of Islam. So we can see then that the feminist project is located squarely within an Islamic discursive framework in which gender equality feminists believe can be reconfigured. And the reform of Islamic law is seen as one of the principal means by which the discrimination women have suffered under particularly androcentric interpretations of Islam can be addressed. Of this, feminists are advancing new interpretations of the sources of Islamic law and theorizing what's known as a liberatory praxis with a Quranic hermeneutic at the very vanguard of this endeavor. In particular, the interpretations of the primary sources of Sharia are being developed: the focal text of the Quran that I've already mentioned, and the Hadith, the collection of Sunnah, the words and deeds of the Prophet Muhammad. So these progressive interpretations of the sources are deployed to formulate an emancipatory agenda for the establishment of gender equality. The project encapsulates the vision of a post-patriarchal Islam, which guarantees women legal, social, and political rights equal with men. This will only be possible, feminists argue, by liberating Islamic orthodoxy from the stranglehold of male-centered interpretations that have become deeply entrenched in the traditional Islamic canon. So thus, by challenging also traditional notions of authority and deconstructing gendered Islamic discourses, feminists are producing interpretations of scripture that can be utilized for the of legal rights. However, before I go on, I should point out that Islamic feminism is characterized by great diversity of opinion, and it's therefore more appropriate to talk about the multiplicity of Islamic feminisms, different schools of thought which can be distinguished along cultural, geographical, and often significant doctrinal lines. This diversity of feminist ijtihad the idea of kind of independent reasoning by which you can interpret the sources, range from the creation of new interpretive methodologies in scriptural exegesis to analyses that are more critical of the relationship between Islam that many share in challenging the hegemony of orthodoxy and of the interpretive methodologies of classical Islam. One of the most striking consequences of the contemporary rise of political Islamism, that I've termed Islamism, is that it has provided a space in which Muslim women have begun to question established versions of their faith in their struggle for gender equality. The Islamist agenda of instituting ultra-conservative interpretations of Islam under the banner of a return to the past and an original Sharia has galvanized women to challenge discriminatory interpretations of their rights. What's been less remarked upon is the problematic convergence in methodological terms between the Islamist discourse of authenticity and the deployment of the notion of authenticity by Muslim feminists. And I'm going to paraphrase, but really there's a real issue here that actually both of them, both Islamism and feminism, are anchored in the central texts of the Quran and the Hadith literature and the reinterpretation of both. Both represent their own interpretation as the expression of an authentic or true Islam, and both discourses have appropriated the notion of a kind of the ideal past of Islam as the foundation of law. Of course, the difference between the two discourses is that they each conceptualize that ideal, or indeed idealized past, and in turn how that past is used to implement a contemporary legal, political, and social order. Thus, the idea of a revival, an authenticity, and a purity of origin, which can be recreated through the mechanism of law, through scriptural interpretation, is pivotal in both discourses. Added to this, I would argue, is the important question of temporality. For feminists carving out a new scriptural hermeneutics, what is the relationship between the past and the present in Islam? A central tension that needs to be addressed is that the Quran is a historical response to a historical problem. Simultaneously, it's also a transcendental text, which is normative, or seemingly normative, and atemporal. And one of the most pressing questions in connection with this is that feminists are also addressing the notion of authority, who is able to create and interpret the Islamic tradition. From the very time of Islam's inception, women were at the forefront in both the production and the interpretation of religious knowledge. However, the further we travel from that time, and
Qudsia, I'm going to give you, they've got 1 minute, okay?
Okay. Well, let me just go straight on to how I think that the connection between law and literature could be useful here. These methodological problems that are really, really quite difficult for feminists, but the link between law and literature, which is very tenuous at the moment, can be useful in two important respects. First of all, there is a great deal of Muslim, certainly contemporary Muslim feminist literature in terms of the creation of literary texts. They challenge and really subvert notions of constructions of women's subjectivity, constructions of womanhood. And so I think that Islamic in terms of reconfiguration law can really look at this material in terms of that subversion of notions of constructions of womanhood and of femininity. And secondly, I think there's also a very useful different approach that can be adopted as well in terms of really a much more foundational and structural reconfiguration and challenge that can be brought about by looking at the nature of Islam itself. And a writer who's sadly died far too early, Shahab Ahmed, wrote a book called What is Islam?, in which he challenges the hegemony of law and theology as the two disciplines that really are constructing Islam and the Islamic tradition. I think Islamic feminism has a great deal to gain by extrapolating that idea of challenging what are the disciplinary kind of canonical kind of traditions that actually define Islam. Shahab Ahmed argues that in fact for real foundational and structural change to take place, we must reconfigure what we understand as Islam and the Islamic tradition. And that would include art, architecture, the cultural production, cultural texts like literature as well. And so I think there's a great deal that can be, this work can kind of, offer a distant aesthetic that both subverts and resists and challenges the traditional patriarchal and androcentric canon that we've inherited, particularly if we're going to be looking at notions of gender equality and reinterpretations of Sharia from a gender perspective.
Thank you, Professor Mirza. We'll next hear from Napoleon, Professor Napoleon.
You muted, Val.
I so look forward to reading your paper. That's really, really important what you're talking about. So the focus of my paper, and I did submit a very drafty draft some time ago, the focus is about Indigenous literatures and about the political and the legal work that those literatures can and should do in our worlds, in Indigenous and non-Indigenous worlds. So I'm thinking about Indigenous literatures in two ways here. First of all, there's a historic literatures where we have non-state decentralized Indigenous societies which have legal orders that included accessible public memories expressed in the form of narratives, oral histories, stories, different forms of expressions. So those can be understood as Indigenous literatures. And these literatures included events, cases, covenants, wars, origins, and they're recorded for future recall, and they also contained the full scope of Indigenous law for those different societies. Recently, I was asked to define and to explain what Indigenous law was, and my response was, it's law. Like, there's often the notion out there, even by many Indigenous peoples, that what Indigenous law is something more philosophical, often idealized, often fundamentalized, and not really very capable of dealing with the actual challenges and problems that law has to be able to deal with, otherwise it ceases to be law, in my opinion. So my work with Indigenous societies across Canada and elsewhere has included working in partnership with communities to restate and articulate those oral histories, law from those oral histories. So this includes authority and legitimacy, decision-making, legal responses, obligations, principles, substantive and procedural rights, like the scope of law. So this is the present day work that's going on for many Indigenous peoples, and it's the present day work of law and society. And that work includes rebuilding Indigenous citizenries. It includes governance and figuring out how to deal with pipelines and violence and child welfare and political and legal relationships with the state and a number of other things. There's also a second form of Indigenous literatures, which are all of the Indigenous peoples who are writing today. There's a whole vast, rich resource of literatures that are really smart, talking about, they take up issues of corruption and sexism and violence and colonialism and abuses of power and all the kinds of things that are a reality of what we have to deal with. So they form another resource for teaching law. So in the drafty paper that I submitted some time ago, I combine some of the elements of historic Indigenous literatures and law with a contemporary telling. And the focus of the paper is the missing and murdered Indigenous women and girls in Canada. So it's a story of agency. It's a story about hope, about law, or about change. And I draw on Cree legal traditions as well as Giksan. So it's a fusion of different Indigenous legal perspectives and understandings of the world. I tell the story of Vera, who I knew as a teenager, and we lost touch. And when I went to go and find her again, I learned that she had been murdered. So I know a lot of women who have been murdered and who are missing. And some are my relatives. That's we just had the Missing and Murdered Indigenous Women and Girls Inquiry in Canada. So there are thousands of missing and murdered Indigenous women and girls. So when Vera is killed, she finds herself in a global village, and it's a village of all of those missing women and girls, of their souls, where they go to rest, where they go to decide whether they will come back in another form, whether they'll be reincarnated, because the dead have agency just as the living do. And so this is her story. And so there's, part of what's really important here is just one of the paragraphs in the discussion that they have is one of the characters is talking to Vera, and she's saying, we're creating new narratives, new stories. And those of us that go back, we take these with us. We're using the architecture of the oral histories from our own societies, like the adaptive management stories. Vera, do you remember the stories that you were taught? Not everybody had that benefit, but those stories are tools for thinking. One of the forms of legal precedent for the practice of our laws. And we need them for the rebuilding of our laws today and our lawful communities. And it's that notion, that idea that lawfulness, like we're always, and Indigenous peoples have always struggled along with everyone else in the world with violence and sexism and oppression and so on. The question is, did people and how did people deal with those things? What are the intellectual and legal resources that are available? So when we think about what is the work of the Indigenous literature, if it's going to be a legal resource, it has to be public, it has to be accessible, it has to enable us to think beyond our own horizons. It has to enable us to think beyond our own political and social containment, so that we can, and to create a repertoire of stories where we solve problems with civility and without violence. So the work that we're doing in communities now on areas of law that have to do with human rights or gender or lands and resources or water, and all the different ways that we're working now with communities to support the research and restatement of their own laws. That's part of what is going on, is the building of a grammar as well as the creation of new resources. So the work requires that we don't idealize the past or our law. It wasn't perfect. It doesn't have to be. It's about rebuilding Indigenous public intellectualism. It's about creative and critical thinking. It's about public debate, safe public debate that's constructive and productive. What happens now, what we see in where we have conflicts, like I don't know if anyone has heard about the Wet'suwet'en conflicts and the huge conflicts across Canada with the pipelines. Those are paralyzed conflicts. People are not drawing on their own legal resources and political resources to deal with each other or with the state. And so what ends up happening is that law is declared and told to each other as statements, not as about intellectual processes to solve problems with one another. So the other aspect here is about rebuilding the civility within drawing on that as part of those legal processes, part of creating the legal processes by which we can work together to connect literature, all that we can think about to creating actual change in the lives of people that are being affected. So that's, you know, it's about resisting the distortions as well, because there's lots of those along with the fundamentalist tellings and the essentializations of women, Indigenous women, into perfect forms that somehow it can be punished when we don't live up to those idealizations. So the story, the paper is in one attempt to capture some of those ideas, bringing together the old and the new literatures for contemporary application. So that's it.
We'll next hear from Ruthann Robson, Professor Robson.
Hi, well, thank you so much for having me on this panel. And, you know, in many ways, I think of like writing law as resistance has really been kind of the story of my life, but also teaching, right? And so what I really want to talk about in the short time I have is combining those three things and a little bit about pedagogy, and very particularly about a course I taught, and I'm teaching again, of course I'm teaching, creative writing for social justice in a law school, right? And kind of earned doing that by teaching a lot of other things, and said, you know, I want to teach this course. Will people actually take it? And people did actually take it. And interestingly, as a way of like moving away from literature in a way and moving towards writing, right? And people as students as creators, right? Creators of both the law and of their own written works and how they would do that. So, and putting writing as a practice, like really thinking about writing as a practice and a way of doing it. So the first class that I have them do, I'm not going to go through every class, but first class, I have students bring in 2 works, right? Preferably books, but not necessarily, but have to be tangible. So if they're doing video or anything else, they have to be able to show it. And then talk a little bit about these tangible objects. And then they pair off and talk about them. But one of the objects, I'll just use book, one of the books has to be something that they want to write, that they feel like, I would have wanted to write this. This is the genre that I want to work in. I would, you know, this is really, really what I want to do. This is the work I admire and see myself as doing. And the other is something that they admire, but think they could never do, right? So science fiction, comics, whatever it is, something that they feel is, yes, I like this, but this is not something that I feel like I could write or I even want to write. So we kind of then pair off and have kind of a cocktail party, which I guess next time we'll do kind of on Zoom, right? And talking about and sharing their projects with each other. And one of the things that has happened has been that the thing that they want to do calls to other people, and the thing that they feel like they can't do also then calls to other people. So I do have a syllabus prepared, but I give them the choice of, do we want to read other people's works and think about all the wonderful things that have been written, including by people on this panel, right, about law and literature and resistance? And the students choose no. They want to workshop. They really want to do their own work. They want to have it as a workshop. We develop the rules about that. Some people have been in creative writing workshops, other people have not. I have some things that I'll share, and we kind of do all of that. And as it turns out, we kind of generally workshop 2 or 3 pieces a class. They also have craft lessons, which I do, usually brought up by problems that the class is having. And so they'll either be kind of craft that I'll get from someone else's work, or kind of from a writing book, or from videos, or from exercises. Sometimes we've just written a story, we've done or just read a story and then written interview questions about the story, or other kinds of pieces. And the other thing that they have to do is the 1,000 words practice, where they have to write 1,000 words. I give them just twice a week. The usual 1,000 words is like 1,000 words every day for a month or 2 weeks or whatever. They have to post those, but I don't read them and no one else can read them. So it's really about the kind of practice and being accountable to oneself about writing and doing it. The genres that people have written in, as you can imagine, fiction, poetry, memoir, those are the basic ones, and those are the ones I kind of expected. Playwriting, lots of playwriting, comics, people writing and drawing, so it's kind of interesting. Scripts for video and TV, which kind of stretched me. I have to admit, I had to go out and do some research about what they're supposed to look like, and all of that. Everything had to have a social justice component, which I would make them articulate. And interestingly, 2 or 3 weeks into the class, some other student would articulate the social justice component for someone. Like, I see that as an immigrant narrative, and it would, fit into this other thing that we've read, or I see this as, something else. Students really switched genres all the way through. And really kind of said, I think to me, one of the most rewarding things besides the content was the genre. I thought I could never do something like that, but someone else has inspired me to do comics or write a memoir, or I thought I could only write fiction and now I'm doing poetry, or I thought I wouldn't be able to share my poetry with anyone else, or that kind of stuff. The last class, we have a reading. I kind of set it up as if we're at a bookshop, and bring in don't bring in any wine, but bring in snacks, and they have to present and read something. And I also do introductions for them, not unlike the introductions that were done for us, but kind of putting them into, in a way, the future, but really talking about their current projects, like best known for his work on looking at slavery narratives and moving from that to current kind of street narrative, right? As if it had already been published. And it really was very, students were very kind of moved by that. And for their project, I mean, they have to submit, you know, X amount of pages, X amount of words, all of that. I tell them in an ideal world, if there are 1,000 words, if they kept up with that, could be their project, right? It's not really a matter of double dipping, but their projects, kind of portfolios, were very professional and well done. And I think for me, the whole thing that, I mean, I certainly get out a lot of it, but really making people feel like and be creators, so that law and literature isn't something that is out there, but that they own it, and that they're not simply consumers, and that they're not simply critics. So thank you.
Great. Thank you very much, Professor Robson. Our fourth and final panelist is Patricia Williams. Professor Williams.
Thank you. It's, you know, I guess I feel I'm so inspired by the prior presentations, and I feel a little cranky, I guess, about the prospect of writing and talking about my writing in a Zoom space. And so I guess that is my topic of, you know, both the necessity and the impossibility of writing as any kind of resistance in the space of a virtual context. And for me, so I guess that's my topic. Because here we sit on a panel that interrogates the literary, speaking in which I guess our papers, but I'm missing the flapping of the sound of papers. There is something that misses the material in this, and delivering this stuff through a non-textual medium. And so it's challenging for me, maybe just because I'm old, but it feels like working behind a giant mechanical mask. And it doesn't feel epistolary at all, at least not in the sense that writing usually does for me, or delivering my writing usually does for me. And even in speaking to you on Zoom or Skype, it feels like, it's like I've cooked a really nice dinner for everyone, a lovely chicken roast with new potatoes and green beans, and then I have to hold it up to the screen, proffering it with a vain imperative, dig in. And, you know, many of us are actually doing that. I have a whole cyber larder filled with people's bread and soups and stuff that they send. I mean, we've all done that in this time. But in order to perform myself to you, I have to stand inside an exoskeleton of myself. And I feel that it really complexifies my ability to be present and to communicate what I would in writing as, again, not just resistance, but as the smoothness of my expression. And worst of all, the machine structures encounters so that I have to watch my own face, sallow and flattened. It instills a consistency of self-consciousness. And it is the material enactment, it seems to me, of W.E.B. Du Bois's notion of double consciousness. I'm always watching myself as I watch others watching me. And so, to me, these negotiations feel, with this kind of mechanical filter, like a form of aphasia. You know, I'm searching for the right word and how to put it through this mechanism to you. But let me shift topics just slightly. In the 1950s and 60s, there was this Harvard research project, the Committee on Primary Records, ostensibly designed to capture all of human experience and to, quote, catalog humanity. And it resulted in the largest trove of sociological information ever assembled. And science historian Rebecca Lamoth has a marvelous book, I recommend it highly, about this largely forgotten attempt to create a massive database of dreams. And the project assembled the stories, lore, practices, personal secrets of people from all around the world. The more remote, the better, according to some of the, the way in which it was weighted ultimately in terms of its research. But the project stored all of this data on technology that then was quite cutting edge. The Redex machine, the Redex machine, or I guess the iCloud of its time. And you may well ask what became of the Redex machine and what became of all that knowledge. And so, as we find ourselves in a moment that really challenges the untrammeled imaginaries of techno-optimism and transhumanist limitlessness, supposedly, it's become a bit of a cliche at this moment to think about what the world will look like on the other side of this pandemic and to make jokes about the singularity. And I find myself wondering how this interface between humans and machines is really transforming us in ways so rapidly that there's very little coherent interrogation. And the shapes of things from the past are being reinscribed into the code, old stereotypes recast into algorithmic reading and readiness. The sociality of the mostly young and privileged male developers and mostly male developers thrown into a social forge and pressed into service with all the very best intentions, no doubt. But this forge is beating, shaping, hardening our means of communication, our systems of interpretation, our vocabulary of representation, our attachments of signification, our ability to exercise the full range of our senses. Now, given that so many of our interfaces have become almost exclusively flat screened, what parts of us are effaced, are left behind as we wander through cyberspace? Is online communication more of an add-on prosthetic, like glasses or crutches or a wheelchair? Does it feel more like an intimate prosthetic or deeply internal part of oneself, an extension more perhaps like what Jean-Luc Nancy ponders when he considers his heart transplant in the essay, The Intruder? I wonder too, are our laptop buddies alive in some sense? If so, what makes their interlocution meaningful beyond the circuitry? And this is a question, I think, of parasociality, perhaps. It makes me think of the movie Her, in which a man falls in love with Siri, or in cases in which people try to marry sex bots or machines. Now, and so I do think about this question of marriage to a machine. After all, we have spent the last months, all of us, in needy devotion, reassuring our computers regularly, I agree, I accept. And I tell these things to my laptop, really soothing me, it's okay. And in turn, it permits me deeper, more intimate access to worlds of delight. I'm not only wedded to it as my partner in sociality, I re-wed it several times a day, professing my troth repeatedly as we cross threshold after threshold. And someone once said that positivists are held captive in a metaphor. And if any of you can remember who, I'd be grateful if you could remind me, because I'm looking for the exact quote. But here we are, caught in a database of dreams, dreamed by some really hardliner positivists. The wonderful late great theorist Barbara Johnson wrote about prosopopoeia in her essay, Anthropomorphism in Lyric and Law. Prosopopoeia being the attribution of life to inanimate objects. And it feels as though that's what's happening with our individual terminals. Their warm, familiar, grayly glowing faces are portals to the great beyond. And I confess, this is not a logical thought or even a sensible emotion, but more of a sense-making thought, sense-making being my new abode, my reading during this long and tragic haul. And I have many concerns about the amount of data collected over the course of our online lives. And I think we tend to read the management of large data stores mostly in the context of privacy rights, that is regarding individual rights, constraints on legal personhood, citizenship, the right to have rights. But I'm wondering right now about the life of data itself. This, as Rebecca Lamov points out, is a question of archive and of memory. And we have to wonder, what memorials do we imagine will emerge from the data of this time? What kind of civilization will we call home after the weathering streams of digitized knowledge carve their mark on our cognition? Lamov writes that the virtual disappearance of the work of the Harvard Project, the Committee on Primary Records, is, quote, a symptom of our own future buried in the present. And she asks, how has this supposedly dream-free substrate called data, with its clouds and servers, its banks and bases, come to be the site of memory? Decisions about what is kept and how, as well as worries about what is lost over the course of a life. And I wonder what will be preserved of our extraordinary moment for what she calls a prospective reliquary. How are our laptop lovers, our cloud clones, our biometric avatars remembering us? How are these algorithmic alter egos preserving us, guarding our thoughts, reproducing our culture, circulating our stories, the literature of our lives? What governance structures, ultimately, are we building to ensure we survive the trip unto some future present? You know, something of ourselves is missing in this moment. Something is effaced beyond the invisible editing of the technology. I feel sometimes like I end up looking more like the machine than I do a human being. And so it's the question to which I keep returning: how is one's being known in a digitized or tile-rendered world? The tile rendering is only one of a number of graphic modulations by which I am transmitted to you, but exemplary for its abstraction. You can look up tile rendering if you're not familiar with that term. What of me you are seeing is the end of a long, what's called display pipeline of optical grids. Depending on the zoom level at which you're observing me, it could be as many as 17 trillion buffered polygonal tiles. And I admit, I love the genius and the gift of this technology. It is my porthole and my portal to a mechanized reassurance that I exist in a world of you others. Nevertheless, it feels as though I am pressing my humanity through a sieve of circuitry. I have to juice myself, leaving pulp and rind behind on the floor. So what you see of me at this moment, what you read of me right now, is my carefully composed persona. You see my public skin, metallic and hard, my being held in the gaze of others, a perpetual conjuration, an anxious shield, a mirror in which the world sees itself. My face is the face of a trickster who appeals to the vanity of others, who obeys the law, the laws, the ever-circling, ever-tightening myriad of laws. A mask of geolocation, metrical measures of my irises and ears, my fake pearls. The formal signification of how I wear my hair, the clothes I choose to cover, and I cover the watery interior, the ectoplasmic mystery that remains with the other me, the one here in this room on the other side, this unconfined forest of imaginings that my apartment has had to become, here with an uneaten dinner waiting on the table for you all. Here she is, this vibrant old woman who looks up at the night sky and evaporates, who misses you all, who waits among spirits, the phantom of me, whose skin is transparent, who abides in a body of vulnerable exposures, pain points, and daydreams, who savors tastes, and is absolutely certain that she, this lover of life, this I, this infinite ontography, will carry on and on and on without end. But this is what's lost to law and to society. And that's what I worry, that this technology simply cannot read. Thank you.
Thank you very much, Professor Williams. All right, Penny.
If you want to raise some questions, Kendall.
Okay.
And then we'll ask the attendees to post questions to the Q&A.
Great, and we'll give them time to do that. Is it possible for me to, well, I'll forget about that. Let's not do that. So the question I'd like to raise is a question that slightly shifts the frame from the relationship or the intersection of writing and resistance to the question of reading and resistance. And it's a question that is suggested for me by the etymological history of the term literature. So just consider the following passage from Keywords, a vocabulary of culture and society, written by the late Marxist literary scholar Raymond Williams, who did so much to radicalize the British literature and society approach. In his Keywords entry for literature, Williams writes, literature came into English from the 14th century in the sense of polite learning through reading. In its French and Latin cognates, it had the same general idea or general sense. The root word is litera, the Latin word wide reading, right? Thus, the main sense can be seen, says Williams, from the normal adjective, which was literate from the 15th century rather than literary, a term which did not appear for the first time until the 17th century as a simple alternative to literate, and which only acquired its more general meaning in the 18th century. Williams goes on to note, literature, that is to say, corresponded mainly to the modern meanings of literacy, which probably, because the older meaning had then gone, was a new word from the late 19th century. It meant both an ability to read and the condition of being well read. That's the end of my Williams quotation. So this genealogically nested relationship between literature and literacy and its negative, illiteracy, has for the most part been forgotten. Once we excavate it, though, it seems to me that the sedimented history of the word literature should remind us that what Williams says about literacy and illiteracy is true of literature and the literary more broadly. They are, in Williams' formulation, key social concepts. So my question is this: as law and society scholars, can we, should we, must we then ask, what might critical attention to the social ground of literature, and more broadly of the literary, help us understand about legal literature and legal literacy that the 1980s or 1990s preoccupation with the formal and disciplinary dimensions of the law and literature question overlooked? Another way to put the question is one concern of the law and society approach necessarily a focus not exclusively or even primarily on the question of writing, or an equal concern with the question of reading as resistance, and with the ways in which the law as a literature, right? The discourse of law itself is both an arena and an instrument for the production and distribution of literacy and illiteracy. And if I were giving a presentation, I'd pull up a series of slides which would show, among other things, the line in Brown versus the Board of Education, the 1954 Supreme Court decision, in which Chief Justice Earl Warren notes that the education of Negroes at the time the 14th Amendment was adopted was almost non-existent. And he says, and practically all of the race were illiterate. In fact, Warren goes on to say, and I'm quoting him, any education of Negroes was forbidden by law in some states. So the criminalization and criminal punishment of Black American literacy and of compulsory illiteracy by law is part of the long history of American race law. And then my next slide would be a paragraph from an extraordinary book, which I've taught by the novelist Ernest Gaines, A Lesson Before Dying. The 29th chapter of which reproduces, you can perhaps even see here, reproduces the illiterate scribblings of one of the central characters, a man on death row, whom the narrator of the story, a Black school teacher in the segregated South, teaches to read. So at a time when 3 out of 5 people in the United States can't read, when 85% of young people who come into the criminal justice system are functionally illiterate, when 70% of people in prison can't read at a 4th grade level, when an appellate court just this year in the Gary B. versus Snyder case has recognized a legal, as a judicially cognizable claim, the claim of Detroit public school students that they are being denied the right to literacy by virtue of the substandard and inferior education that they are receiving in public schools. To what extent are we as law and society scholars under both an intellectual and an ethical obligation in thinking about this question of the uses of resistance to focus as much on reading as we do on the question of writing, on the social practice, if you will, of reading as an important site, perhaps from the bottom, for law and society based or law and society sensitive investigations of this question, which has in our discipline been, I think, crabbed and cabined within the frame of literature. So I'm trying to excavate some of this genealogy of the term literature and the notion of literary discourse as a frame for addressing contemporary law and society questions, specifically this question of literacy. Any thoughts about that as we're trying to locate some of the questions from our colleagues?
Ruthann's got her hand up, Ruthann, and then Pat.
So I think part of my thoughts are, and one of the things or rationales for me going to do this course is that so much of what we read is awful, right? Is alienating, is especially in law school, right? That students come in, at least at CUNY, with an idea to do social justice, and they know that things are bad, and they read and things are much worse than they thought they were, right? So that just reading those words, right? Reading them constantly and making yourself into a passive reader, and the idea that to be literate is to master and know this body of knowledge, whether it's law or literature or both. And that body of knowledge that you're mastering is not just alienating, but cruel and awful. And, where is your place in that you will ever get to? And so obviously I'm not saying, no, we don't read those things, but what else can we do for students and really for ourselves when we are mastering that and being literate in something that is not so good. Let me just put it that way.
Professor Williams, thank you, Professor Williams.
I wanted to add on to what both Ruthann and Kendall were saying, just to observe that there are many forms of literacy. And it's true that we work within a discipline that values the word, particularly the written word, the 4 corners of the document. We are a particular discipline mired in the book. But, you know, we are also in a moment of enormous technological change, and that's affecting everybody. And I think it's unfair to say, or it's perhaps inaccurate to think of our, you know, of the people who, you know, who are deprived of schooling or in prisons and so forth as the only people who are literate. We of a certain age are also illiterate. And it seems to me that at this moment, the necessity not just to be able to read the book in its traditional printed form, but also to be able to read numeracy, to be able to read images, to be able to understand visual culture. You know, photography is writing with light, but, you know, digitized is writing with a different kind of code. Algorithms are inscribing upon our social arrangements something, and we, by and large, you know, are deferring to younger people to be able to read that for us. And so, you know, we're sort of presenting it to them, please read this book for us. So the book is taking different shapes. And that enormous shift in what in what will, I think, be considered literate, numeric literacy and visual literacy has to exist alongside what we've traditionally thought of as, you know, what governs our actions and what is governable in under the rhythm of law. I mean, law is a rhythm. So, I mean, etymologically, I mean, law literally is the old Norse word for rhythm, or for stroke, for beat. So the arrangements are beyond simply the power of the word. They're about the ordering of our numbers and the ordering of our images that make sense and make harmony for us.
Mm-hmm, mm-hmm. It's interesting.
Val or Qudsia, did you want to add anything?
Yeah, I would like to add. So two things. I'm teaching in an Indigenous law degree program. So I teach property law, which means that I teach common law property, and I also teach Giksan property, for which we have no texts, right? So it's a matter of gathering materials. It's a matter of looking at oral histories. It's a matter of teaching students how to analyze and draw law, systematically and critically draw law from the narratives, from the oral histories that relate to property. So it's learning a legal law from a different legal perspective, but understanding that the work is about being able to extrapolate across and think across legal orders. So Giksan law to common law, but also to Anishinaabeg law, which is on the other side of Canada, and so on. Like, people need those skills, which we don't have libraries full of texts. We're grappling with this question about non-text, about other ways to think about how law is expressed, how it's recorded, how it's analyzed, what are the pedagogies, all of the different questions that you have to deal with when you're looking at law, which for the most part has been trampled on by colonization, and that work is rebuilding, but it's law that comes from an oral society. But now one of the skills that people have is reading and writing in their own languages as well as in English. So it's complicated. It's a complicated ground that each of us has to work with. That's part of the issue that matters here. The other is that when we work with communities, and we've worked with hundreds and hundreds and hundreds of like workshops right across Canada with different Indigenous communities, lots of people don't read. Like, we've had the history of residential schools, which is similar to some of the experiences in the States with Indigenous peoples there, where people learned how to do hard labor as opposed to read. And what we've developed are ways of engaging people in the thinking, because people have the scaffolding for the thinking, for the critical thinking, the forms of thinking that can be applied to the analysis and so on. And that's what we build on at the local level, and people can do that. And so there are many forms of literacy, as Patricia has said, and and there's lots more work that we can do to engage people in all of these problems. Like that's the kind of thing that's the most exciting part of the work, is the outside of the university as well as the Indigenous law degree program. So I think that it's really hard work and there's lots of possibilities.
Great.
Qudsia, did you want to, before Kendall continues? I think Quudsia's frozen. Go ahead, Kendall.
Well, shall I turn to the questions that...
Yes, shall I read the question? It's addressed to Val.
I'll read the question.
Okay, go ahead.
This is a question from Jessica Eichler to Professor Napoleon. You seem to describe Indigenous peoples as passive subjects in the way they interact with others by means of their very own laws. Do you see any light at the end of the tunnel in terms of recognition of their laws and legal systems at all? Any illustrations?
Well, thank you for that. I don't understand Indigenous peoples as passive. I understand Indigenous peoples individually and collectively to be active agents, including legal agents in our worlds. And that's the intent to, with the story that I referred to earlier. So the work of rebuilding Indigenous law is the work that Indigenous peoples have to do. And my first concern is that work, that legitimacy, that law as a distinct mode of governance, that law actually do the real work of law that's necessary in the community. That work has to be done first. And then we can figure out what's the relationship with Canada. So that's with a lot of the work, but the reality is that Indigenous peoples are very pragmatic. There's all kinds of arrangements that have been made with Canada insofar as legislation, insofar as different kinds of agreements and structures and education and so on that people have put in place. Law is fundamentally about thinking. And like when I talk about the Indigenous law degree program, it's actually, people have to think through the oral histories. They're about thinking. And that's really, really exciting. So I don't view Indigenous peoples, we have to be realistic about our history, but we're not stuck there. There's a whole rich world that's going on that Indigenous peoples are creating and are a part of.
We have a second question from Mark Massoud. Thanks for a great panel. One of Law and Society's hallmarks is its use of empirical methods like fieldwork, interviews, and ethnography. In what ways can those of us who do empirical research adopt a more humanistic orientation? Treating legal orders and judgments as literature is one way. What else can we do to integrate our empirical work with the liberatory potential of legal humanities? Anyone want to address that question? Ruthann?
So thank you, Mark. I mean, this morning at the first plenary panel, one of the things that the speakers kept coming back to, and I'm sure you've done, Mark, too, is that, the fieldwork diary, right? Like, so that you're both collecting information, right? And you're collecting, empirical research and interviews, but, you're a participant and you're also writing about your own experience in that. And there was I thought, interesting discussion this morning about like, when do you put that in a book? When do you not? When is that part of it? When is that, not part of your project? And as an observer, I was, thinking about like, wow, that's really the part of the project. Like I would really want to read, like, this is happening and I'm interviewing this person, but I'm also thinking this, and I'm also putting it with other things. And yes, some of that obviously comes in the book as well, or the, you know, whatever the project is. But I think that that part of the humanities and the legal humanities, I personally would like more of.
Mm-hmm. Anyone else?
Hi. One of the things that when we enter into research partnerships with communities, it's around questions that the community has identified that they want to learn about, whether it's their relationships, governance of water, or any other legal area according to their legal perspectives. And we never ask people to tell us their laws. What we do instead is a lot of work with the oral histories from that particular legal tradition. We go and we enter into conversations, and a lot of kitchen table conversations about that. And people can say whether we got it right or got it wrong, but it's not an extractive process. They own the materials that are created, and with permission, we share them. So we do have a website. The other thing which I was going to mention is that we don't just produce academic papers. We produce graphic narratives and teaching guides, which I think are really, really important to reach a whole range of folks, and lots of videos, and those are all publicly available.
Anyone else? Andrea McCardle asks, or writes, very much appreciate the focus on reading as well, and these comments that texts take different forms and that the practice of reading is more complex than passively consuming a book. What can we do to encourage more active, critically engaged responses to reading by law students? And there's a related question from Janet Calvo addressed to Ruthann Robson. What are some of the resistance or social justice topics, she puts that word in scare quotes, about which students wrote, and in what format for which topics?
So I guess I'll take that, and then kind of we'll circle back to the other one. So the students' topics were all over the board, and one thing that I saw was a kind of in what form, a searching for the genre. You know, like, how do I want to approach this? So there were sexual abuse stories. There were immigration narratives, both kind of trauma and not, right? Kind of a longing for a different country and using kind of the change in the space. There were prison narratives. There was stuff around reproductive technology, where people were trying to write about the ethics of it and using characters to do that. Sometimes it became a little good scientist, bad scientist kind of thing, but, you know, trying to work that out. There were some, especially in the scripts, some things about a kind of post whatever world, futuristic kind of world. Capitalism is gone, people are driving self-driving trucks or not, the whole, you know, like those kinds of things. Some plays that were set in sort of the time before slavery, trying to talk about how slavery not really happened, but how people came to accept it. A lot of historical research, and then how does that come out in a play or not? And that was really one of the things that she had an issue with. I think that just to go on to the reading as well, I mean, I do think, you know, critically engaged responses to reading by law students, like that's the problem, right? Like that's the I think that is so much about what we do. How do we not just keep people engaged, but assuming that they are engaged, right? Assuming that there's not other problems. How do we have them not be alienated by what they're learning? And that we have to, how can they talk back to these texts even when they have to get the quote rule?
I have a question for Professor Mirza about her presentation. And it goes to this formulation, which I thought was quite interesting, that you offered in your presentation, which you said something to the effect of the link between law and literature is quite tenuous. And then you said, I'm characterizing here that literature or reading literature can help subvert authoritarian Islamic constructions of the female subject and of the nature of Islam itself. And I think you were talking mostly about the contestation within the Islamic world between Islamic feminisms and their other, if you will. And I was reminded of the extraordinary paragraph in the great book by my late colleague, Edward Said, Culture and Imperialism, in which he offers up as an example of the change in studies of the Middle East, a series of works with which you are no doubt familiar. My colleague Laila Abu-Lugod's Veiled Sentiment, Leila Ahmed's Women and Gender in Islam, Fidwa Malti Douglas's Woman's Bodies, Woman's World, a very different sort. And she says these works offer a very different sort of idea about Islam, the Arabs, and the Middle East, which has challenged and to a considerable degree undermined the old despotism. Such works, he goes on to say, are feminists, but not exclusivists. They demonstrate the diversity and complexity of experience that works beneath the totalizing discourses of Orientalism and of Middle East overwhelmingly male nationalism. They are both intellectually and politically sophisticated, attuned to the best theoretical and historical scholarship, engaged but not demagogic, sensitive to but not maudlin about women's experience. And finally, while written by scholars of different backgrounds and educations, they are works that are in dialogue with and contribute to the political situation of women in the Middle East. And I read the passage mostly to invite you to reflect upon the ways in which literature by and about women in Islam can not only help subvert authoritarian Islamic constructions of the female subject and contestation within Islam about the nature of Islam, but also can help transform the legal and cultural imperialism, right, that characterizes non-Islamic discourse about Islam. Do you see some work that literature can do to operate as a resource for scholars like yourself in overcoming the kind of acoustic relegation of the work of Islamic legal feminism to silence or to a kind of subordinate status? Oh,
Have we?
Yeah, I think you're still
Have we
frozen.
lost? He's frozen. There may be another question that you can go to in the Q&A, Kendall.
All right, I'm looking for another question. Let me go. Let me refresh.
Kendall, could you look at the answered? I wrongly did something.
You wrongly did?
Vanderbilt has a question.
Okay, I don't see it.
If
Let me close it. and then open it up again.
If you click answered, it might be up there.
Answered.
But we
Oh,
may have Qudsia back. Qudsia, are you back?
no, she's not.
Hello? Can you hear me? Hello? Can you hear me?
Yes, we can hear you. We can't, your image is
Yes,
frozen.
we can.
I have to say, can you hear me?
Yes.
You can. I
Yeah.
have to say, I'm hearing very little
Ah,
of the Q&A, I'm afraid. It's all very spotty. So I heard very little of that question. I know there's a question that's directed at me, but I heard very, very little of it. But can you?
oh, unfortunately, we can neither hear nor actually see you at this point. So I think in the interests of continuing the conversation for another 10 minutes, we'll go, someone says sometimes turning off the video will give you a clearer audio connection. So
It's Kendall, there's also a question in chat.
yes, I see it. I'm going to go to that. I just wanted to make sure that Qudsia could stop the video and perhaps improve the audio. This is a question from Sophie Vandervalk. Thank you for a great session. This is a general question for the panel. My own research looks at prisoner complaints, where there has been a push to formalize the system into written complaints. This has made the system inaccessible for some due to literacy, but also concerns about being able to communicate in a way that is understood by decision makers. Do you see the law in any way as becoming more formal and inaccessible for people who may not be able to or want to communicate in a formal legal manner? So this is a general question for the panel. Anyone want to reflect a little bit on this question of formalization and informality in modes of communication and expression? Val.
So we spend a lot of time demystifying the law, and we talk about different kinds of law, different organizations of law, what makes law law, what are its legalities, what are the relationships that enable it to be in the world, like all of the different ways that it's a human construct. And we also look at the problems with particular definitions of law. And we do this with people that don't have legal educations. I do this with law students too, about people who don't have a legal background. And it changes the dynamics once law is democratized, once it's talked about in terms of being a human endeavor, once you could talk about the power, and once you can talk about the importance of interpretation, that it's always human beings interpreting the law. Like, so going at and demystifying the law and taking apart those stories that paralyze people, like those are processes of, I hate the word empowerment, it's used so much, but it's a way that everybody can be a public philosopher. It's a way that everybody can be a legal theorist. It's a way that everybody can understand themselves as being a legal actor. And you know, from there, then you can expand and talk about all manner of other things. But it's that first space of people understanding themselves as thinkers, as learners, as creators of law, and you know, different forms, formal, informal law, and then being able to see the law in their own, being able to see their own legal histories. Like that's when communities who have been denied the fact that they were historically lawful people, when those communities and the people in those communities see that, in fact, there are all manner of legal processes and content and so on that they can draw from about land and about disputes and everything else, that's a turning point. But it takes some years to develop for folks to push their own limits critically, and so when we first start, we have 30 people around kitchen table discussions. After 3 years, we'll have 75 or 100. Like, so it's creating that grammar and people understanding themselves and being able to have conversations about their law and legal orders from that basis of knowledge. They can look at Canadian law not just from the perspective of reacting, but understanding that it's a human process, and understanding that there are relations of power, and understanding that they have choices in how they can engage with those relations of power. Law is part of those relations of power.
Pat?
Yeah, I hope that there are human interactions with regard to this. The question actually referred to the formalization of particular kinds of claims. And I think that depending upon the context, that might be referring to an increased use, not just of formal kinds of complaints, but very reductive forms, not just formality, but forms that really frame what can be asked or not asked, frequently which are presented that you have to do checklists. They're almost like checklists. And those checklists, ultimately, I worry, are not really designed to be read by other human beings. They're designed to be read by machines. And they're designed to extract particular kinds of information which can then be fed into algorithms. I think that, Virginia Eubank's wonderful book called Automating Inequality is one, reveals some of the dimensions of this. But I think, I do worry that there is a push for our human complaint in what ought to be, the case and controversy of, witness to witness kind of, the theater of the courtroom is being displaced by calculations based on probabilities of what might happen in the future. Again, by invisible interlocutors, which can't be cross-examined, and which are the information which is taken and then put into the invisible expertise of assorting mechanisms. And that's reductive, that's not human. And I think what we need right now in terms of not just our reading these, but who is reading us, what is reading us, the way in which the machine is an interlocutor at this moment in history we really need to look at how the rules of evidence need to account for these new forms of formalism. And again, both numeracy and in visuals. Because again, I think what I've just said alludes to the role of algorithms, but we're also obviously living in a world where CCTV cameras and dash cams and people are bringing in all sorts of videos. And if our writing is being framed and focused into the kinds of words and literature that only machines can read, so too we need to be able to understand when visuals come into the courtroom, and we have to ask, by whom are they framed? What is the technology of digitization that may alter an image but looks so transparently seeing as believing? And so I think that these are all forms of, again, technology that are bewildering our traditional understanding of, we go to court, we make a complaint, somebody responds, and we have a human interaction. there are different vocabularies and different technologies, and to remember that writing is itself a technology, which is less mystifying than it used to be. But we're on the cusp of again, new literacies that really need to be studied and consider how they are framing our perceptions, and we're not bringing to bear the rules of evidence, which might exclude or at least interrogate what is or is not in the frame.
Mm-hmm. Well, I'm struck, and this I think is by way of a conclusion, by how the law literature traditions concerned with problems of interpretation have been overtaken by a new reality. And it's a new reality which is in part one that, as Pat just noted, is technological, but it's being compounded by these twin developments. On the one hand, the fact to which Pat alluded earlier, and which I tried to raise obliquely, we are living in a moment in human history that I think it's not an exaggeration to call a post-literate culture. At the same time, however, with the rise and what promises to be the eventual colonization of the very world of legal thought and practice by algorithmic law, by artificial intelligence, by big data, we are also living in a world which is post-human, right? So the twin pressures of the post-literate and the post-human, I think, demand some radical thinking, to use Val's phrase, and rethinking about the cluster of concerns and about the human subject and the legal subject that is presupposed by the staging of an encounter between law and literature. And it may well be that the central problem that we face is one not just of interpretation or even articulation in the sense of writing, or even of language, but of representation, right? And the crisis of representation that faces a text and language and word-based social practice whose semiotics have been outrun by the reality that we live in a world in which the human subject presupposed by the world of classical law is enmeshed in both social and technological structures which have to do with the proliferation of representations beyond the logos. And that crisis, it seems to me, is one that will have to be taken up by next year's presidential panel, since we have run out of time.
Patricia just had one quick thing. Patricia, I see you interjected there.
And even beyond representation, the question of affect. I mean, because that's what's happening now. It's like the way in which images speak is beyond simply representation, and it's speaking in dialogue with the words that we're using in courts. And I think affect theory and philosophers like Donna Haraway really are bringing to bear, some, it's post-human, it's also post-representational in a way as well.
Yes, this whole question of, as I put in my communication to you last night, we're dealing with strategies of legal representation and legal structures of feeling, to use Raymond Williams, that exceed the old narrative that law is about reason governed by authority, and that the role of legal thought and legal argument is to persuade as opposed to inciting emotion and inciting and managing affect. What do we do in the face of that reality? What are the forms of resistance beyond writing that we will be called upon to invent and deploy if in fact the description that Pat and I have offered captures something about our current reality.
Well, as chair, it's just my task now to thank you all for a provocative and interesting conversation. I just have one, before we enter the attendees, from tomorrow we will not be using a webinar format, but we'll be using the Zoom conferencing format, which will be more social and more interactive, and you won't have to put your questions to the Q&A. Thank you, Kendall, for moderating. Thank you, Patricia Williams, Professor Napoleon, Professor Robson, and Dr. Mercer. I really appreciate the time you took today, and thank you to the audience. Have a good evening.
Thank you.
Bye.
Great to see you all. Bye.
Great to see you all.
I'll call you, Pat.
Oh, okay. Bye, Ruthann, Qudsia.
Nice to meet you, Valerie. Nice to meet you, Qudsia.
Penny, see you.
So long.